been hard-coded to watch a TV show and go like, hey, that ain't right. So, our panelists tonight, Christine Peak, Stephen Tollafield, United States Magistrate Judge Stan Boone, United States Magistrate Judge Stacie Beckerman, and Circuit Judge John Owens from the United States Circuit Court for the Ninth Circuit. Let's rock and roll with all of the great legal issues from the Acolyte. So first up, Circuit Judge Owens. Let's talk about was Gord's interrogation of OSHA legal?
Well, first I want to say hello to everyone. It's great to be here. One thing I learned from the show, Josh, is that if you're going to be in a knife fight, apparently don't bring a lightsaber. I didn't understand that first episode. But anyway, was that interrogation legal? It's actually a pretty interesting question. We all know if you arrest someone and they're in handcuffs, you have to read them Miranda rights. You all know that from regular practice on TV. And usually formal arrest means in custody. So the question, though, is that there are some times where it's unclear when someone is actually in custody. If you question someone at a police station like you see on Dateline in 48 Hours, you often hear the officers tell the suspect, you're free to leave at any time. And generally speaking, if you are free to leave the interview, you are not in custody. And if you're not in custody, you don't need to have Miranda rights. So the key inquiry is, would a reasonable person in those circumstances have felt that she was not at liberty to terminate the interrogation and leave? But here's the question. When you question someone in their house and they want to leave, where do they go? It's a little complicated. If you interview them at their workplace or in a police station, they can go home. But if they're at their home, where are they supposed to go? So there's actually a case from my circuit called Craighead, which actually deals with this exact situation. And so they list a number of factors. During that interview, was it a police-dominated atmosphere? How many law enforcement? Were they armed? Was the suspect restrained, either by force or by threats? Was the suspect isolated from others? And was the suspect told she was free to leave or end the interview? So now let's take it to that scene. It's very early on in the show, on sub-level bunk 23. I watch these shows with subtitles so I can write these things down. so when we apply those Craighead factors, if you remember the scene in the first episode, it's actually a very close call. Number of law enforcement, okay, only 2 Jedi there. Were they armed? Absolutely. Was the suspect restrained? Not really. Was she isolated from others? Absolutely. And was she ever told, hey, you know what, OSHA, you can leave at any time? No, she was not. So actually, I think you can make a very good argument that the statements here would actually fall into the Craighead case I mentioned and potentially be thrown out of court. However, I do want to point out one thing. I was a prosecutor for a long time. So if I'm prosecuting this case, I'm looking at this picture. And actually, a key fact in this picture is that the door is open. In the Craighead case, the door was closed. And so Craighead said, I don't think I could leave. In fact, a police officer was barring me from exiting the room. The door was shut. Here, the door is open, which suggests maybe she could leave. But I think we know, Josh, that door was open for a different reason. Because something happens right after this that is kind of part 2 of this analysis.
And let's talk about that with Christine. If you could help us out, having the eyewitness come in to do the live, it was her. my lawyer sense went off with like, whoa, no. Help us understand.
Yes, so in a universe that fails to eliminate OSHA as a suspect for Indar's murder, one issue would be whether under the Due Process Clause of the U.S. Constitution, the barkeep's out-of-court identification or any subsequent in-court identification can come into evidence at trial. And the problem that the law is concerned with is that when police identification procedures are suggestive, the risk of a misidentification goes up. on top of that, in this case, we have this factual wrinkle that OSHA and May look just like each other. So that further increases the risk of a misidentification. So the question is whether the procedure is so defective and the resulting identification is so unreliable that it must be deemed inadmissible as a matter of constitutional due process. And there's a two-step test for this. The defendant has to show that the identification was unnecessarily or impermissibly suggestive. And the court then must examine the totality of the circumstances to decide whether the identification is nonetheless reliable. So on the next few slides, you have some examples of a photo lineup or a photo array that may or may not be unnecessarily suggestive. So this first one here has some suggestive elements, although it could be worse. One thing to note is that with the exception of May, this photo array features suspects that are wildly different in appearance from OSHA, which tends to shift the focus towards her and May, and our Supreme Court has noted that in police-designed lineups where the other participants are grossly dissimilar, that could potentially be suggestive. On the other hand, the array does include both OSHA and May, so at least that somewhat mitigates the risk of a misidentification because the witness failed to consider the possibility that it could have been a sibling who appears very much the same. You might also note that May is wearing the same clothes in the photo as she wore in the attack, which could possibly be suggestive towards May, but probably not towards OSHA. And on the next slide, we can actually make it worse by putting all the participants except for OSHA in black and white. Hers is the only color photo, which tends to draw the eye. But what about the next slide, where we have just one photo of just one suspect that's shown to the witness? That situation is called a single person show-up, which can be either live or by photo. And our Supreme Court case law has recognized that a show-up is even more suggestive, and it's generally frowned upon, but it's still not enough on its own to exclude the identification, and at times it might be necessary, such as when a victim is severely injured and their survival is uncertain. So in looking at the facts of the show, is there anything suggestive about the live show-up that Yord and his Padawan conduct? So I feel like the setting could cut either way. It's OSHA's home workplace, so on the one hand, she's gainfully employed. On the other hand, her employment as a mechanic appears to be unlawful, so if the witness realizes that, maybe it could result in some bias against her. And there's nothing to inform the witness that may exist, but on the other hand, that's really not due to any intentional misconduct on Yord's part. He's just ignorant of the fact that OSHA has a sister. And it's not really clear on the facts whether it's necessary to do a show-up as opposed to a lineup. Maybe that witness was going to be unavailable later, or it's not totally clear. So it's a little bit of a mixed bag. There are some suggestive elements, but it's not a slam dunk that it's overly suggestive or unnecessary. So even assuming OSHA could show that it was suggestive in step one, the court still has to consider the totality of the circumstances to determine whether the evidence can come in. So taking a look at some of the factors that courts have recognized as relevant, opportunity to view, well, there is a short period of time when May approaches the bar after Indara is killed, and the barkeep might have had a fair opportunity to view her, but is it really enough? Not sure. Degree of attention, on this one thing you might try arguing is that the barkeep's attention was really focused on the knives that were being thrown right at him, so he must have been distracted. So that's maybe something you could say in support of OSHA. We don't really know what kind of description the barkeep gave, although he's very certain. The audience knows he's wrong, but he's nonetheless quite certain. He says, I'll know her when I see her, that's her. And then the time between the crime and confrontation, well, it's probably not been that long. It might be a couple of days, not totally clear. So this is actually a pretty tough standard. Even though we, the audience, know that the barkeep is wrong, really only one of these factors clearly cuts against admissibility. So this may well come in. So if you represent OSHA and you lose the due process argument, so the evidence is coming in, you still have some other opportunities to attack the evidence at trial. Her counsel could cross-examine the barkeep and explore whether he was aware of his lookalike sister or whether he might have possibly been distracted by the knives. OSHA could request a jury instruction, such as the California example that's shown on the screen, that might call the jury's attention to weaknesses in the identification, and then use that to argue for reasonable hold out.
Excellent. Judge Beckerman, is it legal to delegate prisoner transport to droids?
As you know, in episode 1, the Jedi transport Osha and other prisoners in a prisoner transport vehicle that is run completely by droids, and it doesn't end well. But was it legal for the Jedi to delegate this responsibility to the droids? Let's first take a step back and remind ourselves about the duties that government owes to prisoners in their care. So the government typically owes a constitutional duty to protect prisoners from any inhumane treatment or harm while they're in custody. There's other laws that apply, negligence, such as a tort, and criminal law as well. But can the government then delegate these duties to a third party? And the answer is typically yes. Prisons all the time delegate transport, or not all the time, but sometimes, like U.S. Marshals delegate transport of prisoners to contractors. And of course, everyone's heard of private prisons, which run prisons, who are not the government running the prison. And the Supreme Court has generally held that those private entities are state actors because they are assuming a state function and can be held liable for a constitutional violation if a prisoner is harmed. But the more interesting question is whether the Jedi can delegate these responsibilities to a droid. And the most perfect analogy I can come up with is a self-driving vehicle. So we're in the age of AI. It's developing every single day, and the law is trying to keep up with developing the law of artificial intelligence. And so if a droid or a self-driving car, for example, harms somebody, who's liable for that? Is it the manufacturer who built the car and maybe coded the algorithm? Is it the owner of the car? Is it the car itself? Who can a victim hold accountable for harm by artificial intelligence? And the law is evolving. The tricky part now is AI has become so sophisticated that a coder may not be able to predict, based on whatever they code, what's going to happen once the algorithm goes into this black box. And so a lot of negligence law is based on foreseeability, and so it's going to become harder and harder to hold the manufacturer or the owner liable when what's coming out of the black box is unpredictable. And so legal scholars are advocating for treating AI as a person, AI personhood, much like we treat a corporation like a person, and therefore you might be able to hold the AI itself liable, and experts advocate that AI is going to need to buy liability insurance. So the question is, did this violate the law? Probably not. You can delegate these responsibilities, but we need to make sure that the droids carry liability insurance. As an addendum, because there's so many lawyers here, everyone's talking about all the Supreme Court decisions from this year, and one of them is the Loper-Bright decision, in which the Chevron deference that we've talked about for many years is now apparently dead. And so who are courts supposed to rely on? As we're trying to interpret the law, we can no longer rely on administrative agency expertise. And I would advocate that we should rely on Isaac Asimov, because in 1940, he came up with the law of robots. And as we're looking to interpret the law with respect to AI, I think that we should defer to Mr. Asimov's law of robots. Law number 1 is that robots may not injure humans. Law number 2 is that robots must obey orders unless it violates law number 1. And law number 3 is that robots must protect their own existence unless it violates law number 1 or law number 2. And so coming soon in a judicial opinion, it may be Isaac Asimov's law of robots.
Thank you, Your Honor, because there's always judges who work these things in for fun. So I'm curious to watch what you write. So Judge Beckerman, let's talk about the other part of prisoner transport with using the, forgive me with the Y, the debunk to subdue prisoners.
This topic's a little bit more troubling. For those who watched also in episode 1, Dybbuk is a fleshy, star-shaped, sort of yellowish-green parasite that attaches itself to your mouth with sort of a squelching sound, and it subdues you. It gives you an altered state of consciousness. And the Jedi use this to subdue violent criminals for transport, which is what Osha saw when she witnessed this other prisoner with this goopy thing on his mouth. Do those create legal problems? And you may ask yourself if the Supreme Court has ruled yet on whether Dybbuk violates the law. Turns out, no, not yet. But again, if we look to an analogy, the Supreme Court has ruled on whether prisons may use involuntary psychotropic medication to subdue or control prisoners. And generally the law is that prisons can, so long as there's some due process in place where the prisoner gets a hearing and a review and some assistance. But especially in emergency situations, prisons can involuntarily medicate prisoners. And so this is a form of that, but you might ask yourself, is that the perfect analogy? No, not really, because here it not only covers your mouth such that you can't speak, it also looks to be somewhat painful, or at the very least uncomfortable. So we have to ask ourselves, does this rise to the level of torture? And in the Convention Against Torture, torture is defined to include whether it's severe pain and suffering. So I don't know if this rose to the level of severe pain and suffering, but I think at least it's likely excessive force. And as Josh and I have debated, in episode 1, you were already seeing the Jedi committing various human rights violations. And I think we need to pause and ask ourselves if that was the intent of this whole series, was to question, Jedi 100 years before we have seen them last. Are they, in fact, corrupt cops who are abusing their power, or are they truly the angelic heroes we love, that we hope they are? And as you go through the series, there's a series of human rights violations that cause us to reflect on these questions. But I will leave the answer to that question up to the jury.
Think of what police did in 1924 versus today. Or if you watch Life on Mars, what police work was like in the 1970s and that. So you can think about, we have laws for a reason that evolve. So Judge Boone, let's talk about OSHA's escape from the prison transport.
All right, so when looking at escape, the elements of escape are first and foremost, just a minute, camera. Thank you. First and foremost is confinement, and secondary, an intent to leave that confinement. What is confinement? Confinement denotes usually state actor, just as Judge Beckerman was talking about the prison transport. Similarly situated, is the spaceship a form of confinement? In other words, is it merely a transport vehicle to which one can escape, or is it still in the context of the arrest procedure? Because if you're in an arrest mode, it could result in resisting and not escape. So what you have to do is distill down to its essence, where has it flipped? Where has it flipped from that arrest mode to that confinement mode? In traditional today's times, we often look to a judicial order of some sort to detain that individual, or a sentence by a judge. But usually we have an independent and neutral judicial officer making a determination of putting that individual in that custody, or there are established bail schedules once the arresting officer brings them into confinement. Here, the Jedi, again, we're assuming state actor on the part of the Jedi, the Republic, etc., looking to that, moving them to the context of the transport. There's bars, etc., and going back to the English common law, which is what our system derives from, when moving somebody from the arresting officer to the jailer, anybody who escaped from the jailer anybody who left the confines of the jailer was considered an escape under common law. So here, akin the spaceship, etc., could be that. Some of the defenses of escape are necessity, and I'm going to talk about that with regard to OSHA. Who's prosecutable? Is OSHA prosecutable? Clearly we have a confinement. I believe that is the case. Hopefully, okay, that's good. My wife usually calls right around then. I think she wants to know about that mouth thing. So we have the confinement, but do we have the intent to leave? And I believe that no, we do not have the intent to leave with OSHA, because they tried to get OSHA to leave OSHA didn't evidence an intent to leave. However, I think OSHA could be charged with aiding and abetting in the escape, in that she knew they wanted to escape, and then the last convict, she opened up the door, and then he escaped. So she could be chargeable for that. Now, as to her, even if she was chargeable for escape, is there a defense to that? And that's where necessity comes into play. And the necessity is often derived in these contexts from escape that we see in the law, where, for instance, natural disasters come into play, the jail through tornado, flood, or some sort of disaster, hurricane, the jail is basically opened up and the prisoners leave. That is a necessity which could be applied as a defense. There are no reportable cases at this time about spaceships crashing on planets. So we don't have any reportable necessity defenses in that area.
Thank you, Your Honor. So, Stephen, let's talk about getting a kid to be your pet.
Yeah. So May hires a child on Olega to aid and abet her as an accomplice in her attempt to murder Master Torben. So in the grand tradition of Star Wars characters having ridiculously on-the-nose names, we're just going to call her Ada Obi-Wan. I didn't want to call her the Olega Urchin, which is her credit. So Ada begins the episode with a string of her own petty crimes. She steals something from a passing cart. She chucks it at a droid. So there's a petty theft. Then there's it's assuming the droid can be a victim of a crime and that the droid is a peace officer. That's a battery of a peace officer, not great. And then there's also a little bit of an obstruction crime as she distracts the sentry droid. And now the crimes really start to pile up when we consider her potential accomplice liability under the aiding and abetting statute in California, PC 31, which is not in and of itself a crime. It's just a theory of prosecution that allows the authorities to charge an accomplice with all of the crimes that a primary perpetrator commits. So in theory, aid and abet could be on the hook for May's additional battery of the peace officer, at least a criminal trespass, probably a burglary because she entered the temple with the intent to commit a felony therein, and that also the attempted murder of Torben himself. But fortunately for aid and abet, as we said, you have to, in order to convict someone under the aiding and abetting statute, you have to establish that they knew about the crime that was going to be committed. So while aid and abet probably knew about May's intent to disable the sentry droid and to unlawfully enter the temple, it seems unlikely that May confided in this adorable scamp her entire scheme to murder Master Torben. So I think the prosecution's going to have a hard time establishing that aiding and abetting are the most serious crimes. But in any event, she's just a little guy. Like she's clearly less than 14 years old. So under California law, there's an assumption that minors under 14 cannot form the criminal intent that is required to prosecute them under the penal code. So aid and abet is looking probably at delinquency proceedings in the juvenile court, where hopefully she'll get connected with counseling services, educational services, social support to get her back on the right track. But the next time we see aid and abet, she's clearly in custody by the Jedi. They have her by the scruff of the neck. The Padawan instructs her to stop resisting his physical restraint. So as Judge Owens said, this is a custodial situation where she must have her Miranda rights read to her. But in addition, many jurisdictions, including California, have additional safeguards for the interrogation of minors in custody. So in California, in the Welfare and Institutions Code, you have to have an attorney present when police officers interrogate a minor. And that is a non-waivable right to an attorney in a custodial interrogation situations. Adults can knowingly waive their Miranda rights, but children cannot. So we don't know what happened with aid and abet's initial encounter with the Jedi, but since the Acolyte is not really about giving the Jedi the benefit of the doubt, we can probably safely assume that they did not read her Miranda rights, and there's clearly no attorney present there when Jackie begins her unconstitutional and unlawful interrogation of aid and abet. And I know we have a judge who's repping some justice for Jackie. which generally I agree with, but not in this situation. Jackie is overstepping her constitutional authority as an interrogator of a minor in police
May
custody.
she rest in peace.
Yes.
So, yeah. So I think none of these statements, the incriminating statements made of that made are going to be admissible in court.
All right. Trigger warning. We're about to talk about suicide. This is upsetting to anyone. Want to give you the option to take a step out, and we're about to talk about suicide. So let's talk about Christine May's culpability and liability for Tobin's suicide.
So we've come to one of the heavier topics on the show, and setting aside the earlier attempted murder by a completely different means, and also setting aside the fact that there's probably going to be some problems with the available evidence considering what happens to all of these characters, in theory May would face criminal liability for her role in Torbin's suicide, but how exactly that would come about and what her exposure would be will vary state by state, since the states aren't uniform in how they treat this issue. So the predominant way that states have made aiding suicide criminally punishable is by creating a separate crime to address that specific situation. So on our chart here, California and Georgia are examples of states that have enacted statutes that define a separate crime. And the effect of these statutes is to mitigate the punishment for assisting suicide by removing it from the comparatively harsh consequences of homicide law and giving it a separate classification that's more tailored to the actual culpability of the aider and abettor. So aiding suicide is still a felony in California. It's still a serious crime, but it's punishable by incarceration for a term of 16 months, 2 years, or 3 years, in contrast to the standard sentence for first-degree premeditated murder, which is 25 years to life, so big difference. In California, the major distinction between prosecutions that would proceed under Penal Code Section 401 and prosecutions for murder is the active or passive role of the defendant. So California courts have generally adopted the view that statutes such as Penal Code Section 401 contemplate some participation in the events that lead up to the commission of the final overt act. For example, furnishing the means by which death is brought about, so bringing the gun or the knife or the poison for use by the person that then uses that instrumentality to commit suicide. But when a person actually performs or actively assists in performing the act that results in death, like shooting or stabbing the victim or being the one to administer the poison yourself, then that case falls into the category of murder cases. So one final approach in some jurisdictions is to classify aiding suicide as a unique type of manslaughter. That was just the last little example on our slide. So Hawaii is an example of a state that's taken that approach. But finally, some states that don't have a criminal statute that specifically addresses aiding suicide, in those cases, or in those states, aiding or encouraging suicide could potentially be prosecuted under the laws that are generally applicable to homicide in that state. And so Commonwealth v. Carter, where we have the quote up there, is an example of a case that was brought under the common law on a theory of involuntary manslaughter, which received a lot of press attention mainly because it involved a fact pattern where the basis for the criminal liability was words alone. In May's case, however, she has done more than just encourage Torbin with words. In fact, May's case feels even worse because we, the viewers, know that she does, in fact, intend to kill him. On a separate occasion, she actually does attempt that. So in terms of her conduct that leads up to his death, however, this series shows her placing the poison on the ground and Torbin picking it up himself and consuming it. So under California law, her conduct constitutes participation in the events leading up to the commission of the final overt act because she gives Torbin the means by which he commits suicide. And you could certainly understand her statement offering him a choice between either confessing to the Jedi council or receiving the quote-unquote forgiveness in the form of the poison as a coercive statement. But she does not administer the poison herself. Torbin does so of his own volition. So on those facts, even though her mental state is very culpable, her acts probably fit better under Penal Code Section 401 with respect to the actual cause of Torbin's death.
Thank you. So Judge Owens, let's talk about confidential informants and recording.
Yeah, so kind of like remember old episodes of Miami Vice, they'd send the guy in with the microphone taped to his chest and they'd always rip open the shirt. This is kind of a version of that. So if you're the defense attorney for I'll call him the stranger, as it says in the, when I read it with the closed captioning on Disney Plus. If I'm the stranger's lawyer, I gotta get this statement out. This is a really bad statement. You might recall this is a scene where they send in OSHA pretending to be May. Jackie provides a recording device. She says like 10 times, we're gonna record it, we're gonna record it. So it makes very clear they're gonna record it. And he says some really bad things about how basically they're plotting to kill Jedi. So I gotta go through my toolbox, my constitutional toolbox, as my common law or my criminal law professor used to talk about. It's gonna be tough, honestly, if I'm representing the stranger. So first, is there a Fourth Amendment issue here? The answer is no. I mean, it looks like this is like a bar, kind of, almost like a cantina type situation where the interview is conducted. No real expectation of privacy there. It's expected that people are gonna come in and talk to you. So no Fourth Amendment issue there. There's no real Fifth Amendment issue like we saw with the Craighead, right? Craighead's about law enforcement kind of overbearing someone. And the constitutional issues that arise, it's covert. He doesn't think it's law enforcement, so the Fifth Amendment doesn't really apply. And the Sixth Amendment only kicks in when formal charges are filed, and there are no charges here. So really, I think the stranger's kind of out of luck. Now, one question that was raised when we were talking about this matter is, well, would it be proper to give an informant a gun? Remember that OSHA had given a weapon. The Constitution does not prevent that. There may be policies and state laws that prevent it, but the Constitution itself does not. There is a document that talks about outrageous government conduct, which has got to be really, really, really extreme. And I cannot remember, I've been in this business now since the late 90s, and I cannot remember a time where my court has actually thrown out evidence based on this doctrine. It did happen in like the 80s and 90s, but I can't think of the last time it's happened. So I think that's probably, honestly, a dead end. However, things may change. All right, so the Jedi come in blazing, right? And this is a pretty hostile interview they have with the stranger. And again, we would go back and we would actually apply those same Craighead factors. It's the same analysis. Did this interview cross the line? Did it become custodial? Did the stranger feel like he could leave? I think he got a pretty good argument that no, he could not leave. He didn't think like they were going to allow him to leave. But one thing I want to point out is that the workplace, which I would call this cantina, is viewed very different than the home. And there actually is a case following Craighead, which makes that clear, saying that Craighead says about homes, but if it's in a workplace, again, if they can leave, they can leave. So again, I think a close call. But again, the recording, which is before the Jedi kind of storm in there, that's coming in evidence.
Thank you, Your Honor. Judge Boone, let's talk about May's attempt to steal lightsabers.
So, what are the legal implications here of stealing or attempting to steal the lightsabers? Is it stealing? So, during the fights with Indira and Sol, is that some sort of liability or some sort of conduct? It's really going to get good.
They paused.
Oh, you did. Thank you. Thank you. That's a showstopper. All right. So part of it is when they're fighting, there really isn't any legal implication there because May's argument and defense is that she is merely defending herself during the portion of the fight. It's self-defense. Indira and Sol are not acting in the capacity at this point in time of arresting her. So there isn't this resisting rise to the level. Although later on there could be an argument with Sol that there is resisting, and therefore the attempt to take the lightsaber, the attempt to fight, is a form of resisting arrest. As to later on, when May takes the lightsaber, when Kanaka is dead, what is that? So is that theft of government property? Is it abandoned? Is it individual to that person? Should it go through his estate? A variety of issues. Or does the government own the lightsaber? More likely than not, May was not entitled to take the lightsaber. Merely because somebody is dead does not give you the authority to take their property. So at a minimum, in my opinion, and again, assuming that the lightsaber is government property, that would then be, she would be subject to that.
Judge Beckerman, let's talk about OSHA and perhaps a valid citizen's arrest for May.
In episode 2, the Jedi finally locate May, and first our heroine Padawan Jecki tries to arrest May and says, "You are under arrest, lay your weapons down and surrender." And May flees, and then OSHA tries her best at a citizen's arrest by shooting May with a stun blaster, so basically a stun gun. She misses, and May gets away. But was OSHA's attempt at an arrest legal? Under California law, which is where we are this evening, a private person may arrest another person if the public offense is committed in the arrestor's presence, and a public offense is basically a misdemeanor or a felony. So if you see somebody in your presence commit a misdemeanor, you can arrest them. Second, if somebody has in fact committed a felony. Or third, if you have a reasonable cause to believe that the person has committed a felony. And then the second question is, may the force be with you as you are effecting a citizen's arrest? May you use force? The law tells us that you must use only a reasonable amount of force that's necessary under the circumstances, and you can only detain a person long enough for the police to arrive. So here, May did commit a felony, murder, and so that satisfies the statute. And OSHA used a stun gun, which I would hold as a reasonable amount of force under the circumstances. Contrast that to, I once had somebody write up an arrest warrant to come arrest me because they didn't like an opinion I wrote. That is not a valid citizen's arrest. And so, for example, as you are here in the state of California this evening, if you leave here to walk over to the Star Wars after party and you see a costume that you think should be against the law, you can't arrest that person. But if the same person urinates on the street in front of you, you can arrest them. But I would advise that you do not.
Yeah.
So you're saying there are no fashion rules. So Stephen, let's talk about what happens with the stranger and May here.
Yeah,
With
so-
wanting to kill a Wookiee.
Right.
Whether that's an enforceable contract.
Right. So May has just learned that OSHA is alive, and Hemir, sort of his identity, the stranger, has started to sense that May's resolve to kill the other Jedi is flagging, and he admonishes her that they have a deal. She has to kill the Wookiee. And then later in the episode, when May has disabled Hemir, or so she thinks, she repudiates her obligations under the contract and says that OSHA being alive changes everything. My loyalty is to OSHA, not your master. So it got me thinking whether this new information under US law would actually excuse performance under a contract like this. And we should say right off the bat that obviously a contract to hurt or kill someone is illegal. Just like pretty much any contract in Star Wars that's for an unlawful purpose, is like all of them, you can't do this. So no court's going to enforce that contract. But assuming it is a valid contract, this situation raises two kind of overlapping, related but distinct principles: mistake and frustration of purpose. Mistake is a defense to contract formation, which is a sort of a misunderstanding about some key underlying assumption of the contract, and which materially affects the bargain. A frustration of purpose is a excuse of performance for a valid contract. And it's when one party's purpose or primary purpose for entering into the contract is substantially frustrated. And I think here, May has pretty strong alternative arguments under either of these principles. May's whole point or whole purpose of selling her soul to the devil, essentially, in order to get the power and opportunity to kill Jedi, was to avenge her sister's death. Her sister's not dead, so there's no death to avenge. She's not getting any benefit out of this contract. So I think either way, this new information materially affects her bargain, and it also substantially frustrates her purpose. So I think May is correct, actually. She's quite the legal scholar, that OSHA being alive does change everything for this contract.
So, question time. So you can line up the microphone. I want to highlight, this is not legal advice. If it was, there would be a bill, there would be all kinds of things that you'd be signing. So
Also, the judges want to reflect that the views that we express do not reflect the views of the United States government or our respective courts. There
All
we go.
right, we got 10 minutes, so hit us.
I come to your panel every year. I love you guys.
Thank you.
Thank you.
So my question is specifically about the book. The book.
Okay, yes.
So totally different franchise, but one of the things we learned from Venom is that parasites can be intelligent life forms. So what I'm curious about is, do we know how intelligent the Dybbuk is, and depending on that, is there legal room for laws related to animal welfare to come into play, because the Dybbuk is being exploited or employed for this purpose?
So we don't know yet, so I expect the character or creature encyclopedias to be a little more defined in the future. I think something that's comparable is the Bogoli from Rogue One, which also has the same, it's mind reading, but it also has the psychotropic effect. And so while I do not approve of recreational Bogoli use, I think a similar position can be said with the Dybbuk as well. So thank you for always being here.
Can I add a PS? It's a really good question, because if you remember, OSHA uses PIP to basically electrocute or sort of tase the Dybbuk, and it reacted. It came off the mouth, and it appeared as if it felt pain, and then it retreated and left the ship. So that supports your question that maybe there is an animal welfare concern here. So it's a good question to think about.
Thank you. Ken.
He's just Ken.
I have a separate question about the contract between Camille and May. I understand May's promise to kill the Jedi. What consideration should receive in exchange for that?
That's a good question. It's really unclear what the promises they exchanged were. Kimir, the stranger, keeps saying that he wants an acolyte, he wants a trainee, so that presumably that's her consideration to him, that she's like
Right.
selling her soul to, it's very Faustian. And then I guess in exchange, I suppose that he's giving her the training and kind of the opportunity to exact her revenge, because the targets of her vengeance are Jedi after all. So she's going to have some additional training. But that's
Yeah, all you need in contract is a mere peppercorn, as we all know from contracts. So I would agree that the training is probably
that's what I
take out the illegal stuff.
Yeah,
just,
exactly.
Just go to the
The whole
training.
killing. Great question though. That's really unclear. Yeah, good.
Hi.
The Jedi are often referred to as peacekeepers, and in the analogies we've been talking about today, you compare them to the police. But I'm wondering that what we've seen them do across all the movies, they're not a lot like the police that we know. I'm just wondering, is there a real world analogy that you think would best apply to what the Jedi do? If not police, would it be something else?
Warrior monks. It'd be like the Vatican having an army.
The Swiss Guard.
Like the Swiss Guard, if the Swiss Guard was ever deployed.
United Nations, perhaps?
Yeah, United
The
Nations.
peacekeeping
yeah.
forces of the United Nations.
Yeah, like the UN, so the blue helmets being sent in. Something that was more prevalent in the 90s, that we know there are situations where we do send UN peacekeepers in, but post-war on terror is different, just different now.
Or maybe Disneyland police. This is very peaceful there.
Don't go that far.
Or maybe our new
it's
Space Force, does that still
Space Force.
exist?
Space Force. I like it.
Tachi.
Yeah. Anybody here is from Disney, I apologize.
That's a good question. Thank you.
Sort of in a similar vein, we talk about the Jedi as a sort of police force, but they are trained from a very young age. So in regards to the culpability of Jackie, who is 18 in the show, would she, I suppose, be held accountable for her actions breaking the law if she was trained in a sort of religious cult that allowed her to believe in the good that she is doing? I don't think there's any like case law around this because we don't train police from a young age. But
Judge Beckerman and I were discussing elements of this. Your Honor, do you want to take part of this, and I'll take part of it?
Well, I think typically, a criminal defense of my cult made me do it is not a valid defense. But even more concerning, what Josh and I were debating was the fact that the Jedi is, in a sense, conscripting child soldiers from a young age when they go find May and Osha and take them away from their mothers, not to necessarily fight, but to train to be fighters, so to speak, raises some serious human rights violations. And right, Jackie was only 18. She was just a child.
So think of it this way, that we have mandatory school requirements for minors. And so with the twins not being in school, there's an argument that they should go to a Jedi school to learn how to use the Force, because they're not enrolled in any school anymore. However, the witches don't have state credentials to teach the Force as well, so if they were credentialed, it'd be a different situation. However, you get to go home from school. If you're good at basketball, you don't leave the family and never come back. So there are things that are comparable, but a lot of things that aren't.
Yeah, but you get a really cool lightsaber, and you can, and you learn to do that. You know, that is, I mean.
At the National Panel, they said the Valence lightsaber is going to be coming out. So again, there's lots of excitement. Yes, sir.
Hi, my name is Chris. I'm very glad you brought up state credentials in your last answer, because essentially the Jedi have been endorsed as religion by the government. So couldn't the coven sue the Jedi for a violation of the First Amendment right, as they're not allowed to teach their religion to young, but the Jedi can all across the galaxy?
There are big issues with that. Thank you for bringing it up. And your voice is familiar. Are you a Star Wars lawyer?
That is correct.
Force is,
Love you on TikTok. Follow that man.
Force is strong in you.
Rockstar. Yeah, there's a lot there. So I do think there are First Amendment issues that the witches have a right to practice their religion. The Jedi have the right for theirs. The two colliding is highly problematic because both are, you have freedom from religion as well. So it's a mess. I don't like where this goes. All of this is misunderstandings and escalation, and no one de-escalates, which is why this ends badly. So, but it's problematic, and I do think the witches have a right to practice the thread and encourage others to do that as well.
Thank you.
And hang on afterwards. It's good to see you. Yes, sir.
So sorry, two gentlemen before me asked my original question about judges not needing coaches anymore. But falling back to that, in the casting and/or TV show, we get to see what a court system in Star Wars looks like. But of course, it's under the Imperial regime. What do you think would be different in the Old Republic, and would we actually get to see counsel if we saw the inside of an Old Republic courtroom?
So, thank you. Andor is the first time we actually see a judicial process in live action, aside from the Clone Wars Trial of the Jedi. That was very Soviet style, bad. We don't like that. I'm hoping that we do see a real trial with lawyers. I want the Star Wars procedural, but that might be a very narrow audience. But it's a hope. It's a hope, and I would hope in the Old Republic the system is more defined and actually has civil rights and equal protection under the law. Because the New Republic, when we get to Ahsoka, that's a train wreck with the weird hearing that Hera has. So with that, it's our time. Well, we got 30 seconds. And then we'll be outside. So any other questions for the good of the order? Thank you for that question. Thank you all for being here. Thank you.